We are back on the record in cause number 252-6407. State of Texas versus Sierra Torrance. Please, guys, if you announce yourselves for the record.
State Kelsey Stiegler.
The state William Thomas.
Anna Edie for Ms. Torrance.
We have reset this thing at least 4 different times, I would imagine, because of this bond violation. One, I guess, evidentiary reason for Ms. Edie to get evidence. Last time we were here, we were going to have a hearing. Unfortunately, we didn't have our pretrial services officer here. She's here now. So that's why we're having this hearing now to determine whether there is a true bond violation. Ms. Torrance is on bond for DWI that was initially filed August 28th of 2024. It's a second offense. So she was ordered to obtain a guardian interlock, or if she was not going to drive, obtain a portable device, and to blow in this portable device as according to the blow schedule. Our first bond violation report was filed October 8th of 2024. And I'm correct in saying that no action was taken on that bond violation.
She was admonished and
I admonished her. We did not do anything at that time. We now have another bond violation report that was filed January 24th of 2025. And in this bond violation report, we have 13 skip tests on random days. And then I think that there were other issues as well. But I guess for me, the main concern would be that she's not testing when she's supposed to.
Okay.
The floor is yours, Ms. Edie, if there's anything that you wanted to say.
Okay, well, let's see. The only thing I see alleged in the bond violation report is just the skip test. So I just want to make sure we're all on the same page. I don't know that there's any other allegations.
Okay.
That's correct. Okay, okay. This is not my hearing, Judge, so I don't, if the state wants to call somebody or, you know, they have the burden, so whatever they want to do, I'm happy to respond, but this is their.
Your
So
Honor?
tell me what happened with the missed test, if you don't mind.
Yes, Your Honor, we can call pretrial services Miss Felicia Chiles if she is available for one moment.
Okay, do you mind coming up? Raise your right hand, please. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay? State.
And first,
Judge, would you please take judicial notice of the court's file, which is a copy of the information?
Okay. Any objection?
I'm okay with the information. I would object to taking judicial notice of the report.
Okay.
So I'm not sure what all is included in the file.
we were addressing about the defendant here being charged. That's why we're asking for judicial notice of the court's file regarding
Okay.
that element that we need to prove today.
Sure.
So
All right, Ms. Chiles, Giles, apologies. Is the defendant on bond or court law number 5?
Issue?
Yes.
Yes.
Are you familiar with the bond conditions?
Yes.
Your Honor, may I approach?
Yes, sir.
Is this a fair and accurate representation of the bond condition for the defendant?
Yes.
You recognize that?
Yes.
What is it?
They're the magistrate's conditions for the defendant.
Similar to the defense, Your Honor?
Okay, please. Any objection?
No objection.
Okay, they'll be admitted. States 1, I guess.
yes, sir.
Okay.
Could you please describe the bond conditions?
Yeah, you want me to like read all of them? Or like all of them?
Yes, we don't have to check.
Yes. So we have defendant shall personally appear in court on time every time the court, this case is set on the court's docket unless judge waives the appearance. Defendant shall commit no crime or shall not engage in any conduct that could result in his or her arrest. We have here that they're to obtain an ignition interlock device within 7 calendar days. Is this the most recent condition? Doesn't she have a portable device? The device. Are these the most recent conditions? Because these are the IID ones. Can I have a moment to look at that?
Yes, please.
These are not the most recent bond conditions that are in place. These are the first ones from the magistrate. Right now I'm printing out the amended bond conditions that were created on September 4th, the ones that we're referring to with the portable device. So the first two conditions are the same that I had stated. However, instead of the ignition interlock, we have the client is to obtain a portable device within 7 calendar days. And that would be from the date of August 28th. And then no driving without permission of the court. We have no drug or alcohol usage. And then that same day, the defendant also was required to submit to a POC test and return to court.
Your Honor, would you like me to tender these updated
Sure, of course.
with the defendants?
So two, I guess states two would be the amended conditions of bond.
We're calling this stage 3, if that's okay, Your Honor.
Okay, sure.
And I have no objection to this.
Okay, it'll be admitted.
Now we will be addressing the bond violation report.
I'm asking the witness,
Sure.
you recognize that?
Yes.
Is that called?
It's the bond violation report?
The fair and accurate representation of the bond violation report.
Yes.
All right, could you please explain the violations of?
Objection, she's reading from something that hasn't been admitted yet.
Mistake, Your Honor. I can tender this to the defense.
Oh,
This will be admitted as state's exhibit number 2, Your Honor.
Okay,
no objection.
all right, it'll be admitted.
Can you please read where it says details of violations indicated here?
Yes, the details read that the defendant was instructed to obtain a portable alcohol testing device and refrain from alcohol consumption from December 9th to January 14th. The defendant has generated 13 skip tests. Pretrial is unable to properly supervise the defendant if the defendant is failing to provide samples during the scheduled timeframes.
Wasn't it a condition of bond to complete those portable tests?
Yes,
And how many again were not completed or were missed?
13.
And what were the dates?
Between the dates of December 9th and January 14th.
Thank you.
Any further questions for the witness?
No, Your Honor.
Okay,
Do they prepare a report of the missed blows with the specific days?
Yes, and that was provided to everyone here's email last week or
Okay.
the week before when we had discussed it.
Okay, Ms. Giles, what is your job title, exact job title?
Judicial liaison officer.
And what do you do as part of your regular duties?
I am the face in the court for pretrial services, so I create bond conditions that are requested from judge and instruct clients over things that I can instruct over, so conditions that don't require devices in court. And if not, I send them over to our pretrial services building for further instruction.
Okay, do you know how the portable device works?
I'm very partially familiar, but not thoroughly, no.
Okay, do you know how the software in the device works?
No,
And do you have any idea how those work together?
no.
So when you get a report, you have no way of verifying whether that information is accurate.
The vendor sends us the full report to our case managers.
And was the full report provided in the email that you referenced earlier?
Yes,
Okay, but there's no way to know that that device is working properly from your personal knowledge.
for me to validate if it's working
Mhm.
correctly, me personally, no, but our case managers do verify it.
Okay, I don't have any further questions for this witness, Judge.
okay. Anything further?
No, Your Honor.
Can the witness step down?
Yes.
Okay, thank you so much. All right, I guess argument. Or do you have any more witnesses?
No, Your Honor.
You have any witnesses?
I do not.
Okay, argument.
So, Your Honor, this case is pretty clear. It's a simple bond violation. The defendant here was in fact charged. We ask you to take judicial notice of that fact. And we have proven such, and that this defendant is on bond in county court at law number 5. And we just discussed the bond conditions that were pretty standard. And the violations here very clear that there were 13 missed portable tests. And our pretrial services was able to confirm that, and we would ask that you would revoke the bond in this case.
Judge, This is, the rules of evidence apply at this hearing. This report is testimonial. Since it is testimonial, I have the right to confront someone with knowledge about whether the machine itself was working properly, whether the software was working properly, whether the two were working properly together. And we reset this to today to get someone here who had that knowledge, was my understanding. And without that, I can't.
I didn't know about that. The only one that I knew that we were supposed to have here was Ms. Childs as with
Yes,
regard to
Your
this, not anything else.
Okay,
All
well-
okay,
And we
go
would
ahead.
say that the defense also has the ability to subpoena as well.
And this was set on Thursday, and it's also not my hearing, it's not my burden. I think without someone to testify that the machine was working properly, it's inappropriate to revoke her bond, restrain her liberty, the pecuniary punishment that goes with the bond revocation and paying a new bond, without knowing that the machine was working properly.
But that's on them. If there's a problem with the machine, then it's on them to go have its service or whatnot. So
Does she know it's
all I
working?
know, well, then you're supposed to go there. You're supposed to go get it checked out. We can't micromanage every single thing. Number one. Number two, this is not the first time we've had this bond violation. We've had it before and it continues to happen. I can't just let it go, man. I mean, I have to show you that we mean business. If I let you go now, then I'm enabling this behavior and I'm in effect telling you it's okay when it's not okay. You're skipping tests. It's a second offense. It's time. All right, I'm revoking her bond. She goes with you. It doesn't make me happy to do it, but I mean,
I
it's
understand.
bond violation after bond violation. I mean, all right, off the record. All right, we're cause number 2537045, State of Texas versus Emma Lynch. Ms. Lynch was picked up at DWI November 4th of 2024. She was ordered not to consume alcohol or illegal drugs. We now have a bond violation report. Today's date is February 3rd, 2025. Can you please identify yourselves for purposes of the record?
For the state, Kelsey Siegler.
Anna Edie for Miss Lynch.
Okay. So Ms. Lynch we are here now. Again, this also is a second bond violation report. The first violation was November 20th of 24. We now have another bond violation. It is a report that was filed on the 29th. Okay, State, if you'd like to.
There is slow, if you can just give me a moment, but this case is regarding this similar, not of skipping testing as well. And I'm trying to print the bond violation report and the bond conditions, just one moment. But we would call as our witness, pretrial services, Felicia Stiles, again.
Okay. Ma'am, would you come on up? Would you raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, please.
Thank you, Ms. Childs. Are you able to show us the bond conditions on your end if you have them on your?
Yes, would you like me to?
Yes, ma'am. Thank you. And Your Honor, we would like, if you could please take judicial notice of the file as well here regarding
Sure.
the
Any
defendant being
objection?
charged for this.
I have no issue with
Same as the last one.
correct, with the information.
So no objection to taking judicial notice of the file, however, not of the actual report, of the bond violation report just yet. Let her take a look at it.
Yes, sir.
So again, State's one will be the actual condition of bond report.
Yes, sir. Do you recognize this? Yes.
Yes.
What is this?
Bond violation report?
Can you please tell us what the bond violations were in this case?
Yes.
Oh, wait, let me actually refresh that. Do you recognize this?
Yes.
Okay, what is this?
Conditions. For the defendant.
Your Honor, we will tender State's Exhibit 1 to defense for any objection regarding the bond conditions in this case.
Judge, this says that never mind. I misread that. No objection.
State offers State's Exhibit 1 into evidence.
Okay. Will
Ms.
be
Childs,
admitted?
can you please tell us, thank you, Your Honor, sorry. May you please tell us what the bond conditions are listed in this case that defendant Lynch was supposed to abide by?
So December 3rd of 2024, we have defendant to appear in court on time every time the case is set on the court's docket unless judge waives the appearance. Defendant shall commit no new crime or shall not engage in any conduct that could result in his or her arrest. The defendant was required to obtain a portable alcohol testing device that same day, December 3rd, to submit to random drug and alcohol testing, to not consume any drugs or alcohol. And yes,
These are pretty standard for this kind of case, correct?
yes,
Thank you, ma'am. So regarding what's been marked as State's Exhibit 2, what is this?
a bond violation report.
Does this fairly and accurately depict a bond violation report?
Yes,
State tenders defense for any objections.
I would just object to, in this State's Exhibit 2 bond violation report, there's a reference to a number of skip test. There's no dates on here, so I'm not quite sure which ones, based on the four corners of the document, we're addressing.
Okay, I guess we'll be getting into that now.
Right, yes,
But-
sir.
Okay.